Hello everyone, welcome to Steno Aspirants. I am Akshay and I am going to dictate you a legal passage on climate change and litigation cases containing 500 words at the speed of 100 words per minute. So get ready, 3 seconds. Start. Part 1 of this article initiates the debate by making out the increasing popularity of climate change, litigation worldwide, and its conceivable future in India's top. Part 2 further narrates the potentiality of such litigation stop. Part 3 seeks to draw a broad framework for climate change litigation by discussing some of the cases that originated in United States of America. Stop. Part 4 takes the discussion forward by analyzing the feasibility of applying US experiences on Indian litigation scheme. Stop. Part 5 focuses on social and ethical aspects that influence climate change litigation, and finally part 6 concludes the paper. Stop passage. Climate change litigation finds its roots in liability claims as civil society is becoming aware of the fact that human actions and the emission of certain greenhouse gases into the atmosphere can lead to grim consequences for the environment, property, and human health. Stop. It creates the possibility of future litigation against governments or corporations engaged in commercial activities. Stop. Once commenced, it raises whole new legal challenges of which both plaintiffs and the defendants must be aware. Stop. Climate change litigation can be spawned from stop passage. Actions of nuisance and negligence are very common in India when it comes to check environmental pollution in the present scenario. Stop. But unfortunately, none of them have been used so far to include climate litigation purely. Full stop. Nuisance can be of two types, private or public. Stop. A private nuisance takes place when one uses one's property in a manner that harms the property interests of others. Stop. Theoretically, if a company uses its property in a way that harms others' property interests by contributing to global warming, it can be held liable under private nuisance. Stop. Climate change, however, is a broad problem that has less to do with defendants' use of their property and that involves much less direct annoyance with neighbors. Stop. Therefore, private nuisance does not seem like a good option for a climate change lawsuit. Stop. Public nuisance is a more appropriate remedy for climate change cases. Stop passage. Over the last decade, the number of cases involving climate change has increased noticeably. Stop. Several cases have already been filed in national and international tribunals worldwide. Stop. United States has experienced a surge of this kind of litigation. Stop. It was one such case, and the US Supreme Court's decision in the same has significantly altered the government policy and redrawn the litigation landscape. Stop. Several others brought claims against the US Environmental Protection Agency, challenging the agency's decision not to regulate emissions from motor vehicles under the Clean Air Act 1963. Stop. It contended that under the Clean Air Act, EPA had the responsibility to regulate any air pollutant, including greenhouse gases, that can reasonably be anticipated to endanger public health or welfare. Stop. The US Supreme Court decided that the Clean Air Act 1963 does give EPA the power to regulate stop. This case is a typical example where the Supreme Court of USA decided an administrative law question whereby avoiding a much disputed issue of scientific evidence for climate change stop over.